What is going on, everyone? Badger here. Make sure to like and sub, and let's get into this. Obviously, Gina Carano is going through with her lawsuit that is being backed by Elon Musk. Elon Musk's lawyers looked at her case and said, you were fired after posting political commentary on Twitter. I'm doing this in broad strokes for the comparison. You were fired on Twitter, apparently, for using political commentary on Twitter, the same exact thing that other employees were able to do and not be fired for. So even though California is an at-will state, this is being framed as discrimination based on gender, that they treated their male employees, i.e. Pablo, who called half of America Nazis if you voted for Trump, and likened us to the Civil War, the South. No problem with him, but Gina, of course, was going to have to go through struggle session after struggle session. So here we have legal analyst reacts to the Walt Disney Company's motion to dismiss Gina Carano's lawsuit and saying it will be another huge fail for Disney. So legal analyst Andrew Esquire, of course, who hosts Legal Mindset YouTube channel, and I just will call him Legal Mindset, shared his opinion on the Walt Disney Company's motion to dismiss Gina Carano's lawsuit. So of course, that Disney filed their motion to dismiss on April 9th and claimed Disney makes this motion on the grounds that Disney has a constitutional right not to associate its artistic expression with Carano's speech, such that the First Amendment provides a complete defense of Carano's claims. It also states Carano's claims are all barred by the First Amendment, as the Supreme Court held in Hurley versus Irish American Gay. Okay, so they're doing a statute thing here. The First Amendment embodies a core principle of speakers' autonomy that bars the state from dictating to expressive enterprises what to say and how to say it and whom to say it through. It continues, as the court further held, the principle that means that a state cannot force an employer to engage in speech to speak through an employee whose views on public profile could compromise the employer's own message, even if the employee does not express her views on the job. Okay. Finally, the motion asserts what state law cannot do, however, is force entities that do create speech products to speak through writers or singers or actors whose own speech and public profile could, in the employer's view, compromise the employer's ability to express itself in its own chosen manner. Carano's suit contravenes that rule. It is an impermissible effort to invoke state power to override a private entity's decisions about what to say in its own art and how to say it. The complaint should be dismissed, Disney concluded. Esquire reacted to this motion stating, the Walt Disney Company is setting up for another huge fail when it comes to the First Amendment and trying to dismiss the Gina Carano case. He elaborated, this is a very interesting case. This is a case that it's shocking that Disney is going with the same failed argument that they tried before. Now, why do I say this is the same failed argument? Well, we know that Disney has just settled its case in Florida and actually admitted to illegal wrongdoings in the case, saying they did what it did in Florida was indeed illegal, that it was wrong, that there was no First Amendment basis for any of its claims, that the whole First Amendment argument, we had the right to say something, it's completely bunk in that case. Well, now in a shocking motion to dismiss filed in the separate Gina Carano case in federal court, they are saying that her claims are barred because they have a First Amendment right to not associate with her, to disassociate from her because her artistic expression, her words were harmful to the Disney brand, so they're going to want to disassociate with that. Well, the funny thing there is nothing about that defeats any of the claims of her nature of sexual preference or sexual bias, right? Because on the fact that Gina Carano, a woman, was fired and Pedro Pascal and several other men were not fired for saying the exact same things, for using, in fact, more abhorrent language and in some cases making very, very, very offensive jokes of the exact same, precise same nature and not being fired for it. And yes, good. I'm glad that my understanding of this is the same as an actual lawyer, that they literally fired her for doing something they let the men get away with. And that is the key distinction there. Esquire then stated, so they filed a motion to dismiss, which really doesn't address the merits of the claim or really prove that it is a meritless claim. Remember, a motion to dismiss is supposed to prove that they lack merits completely, that there's zero merit, zero substance to the case, and to the Gina Carano case. And what we see here is, in fact, that, well, that's not addressing whether or not these claims of preference are actually merited one way or another. It also doesn't address any of the labor laws, because these are brought under very specific labor laws, which have absolutely nothing to do with what Disney is claiming. This is about punishing Disney's speech, right? So Disney, once again, using this First Amendment defense is very weird, because it's not about them. It's about the firing of an employee, and firing of an employee for their political views, which of course in California is illegal. By the way, it's illegal whether they are left-wing or right-wing. It doesn't matter. It is apolitical. Esquire elaborated, if you are firing somebody in California under California labor law, whether they are on the left or on the right, it doesn't matter. You cannot fire them purely for the basis of those political views. That's California law. That is under their labor laws, and that is the core of the Gina Carano case, which this motion to dismiss completely fails to address. Next, Esquire predicted, therefore my prediction here is that the motion of dismiss will actually fail, and this will indeed proceed to summary judgment, and more important, to discovery, which has always been the goal and the huge win for Gina Carano, particularly with funding from Elon Musk to get Discovery into Disney, to get emails, to get phone calls, text messages, meeting notes, and all sort of fun stuff about the discriminatory intent that lies behind Disney's actions. Could you imagine when we get the emails proving that former Harvey Weinstein assistant and showrunner Leslie Headland of The Acolyte was one of the key players to getting Gina Carano fired and or trying to get her in that struggle session full of LGBT complainants? Yeah, that was her. Can't wait. Let this go to Discovery. He concluded, particularly they're looking at people's political beliefs and deciding whether to fire somebody or not fire somebody on those basis, which would be the core of Gina's complaint. So we'll see how it goes here. But my prediction is the motion to dismiss will indeed be denied. Previously, Esquire accurately predicted that the Walt Disney Company's lawsuit against Ron DeSantis in Florida official would be thrown out due to lack of standing during appearance on WDW Pro channel. Esquire said June 2023, for Disney, the nightmare scenario, the worst possible scenario, which is a likely scenario. I don't want to give the exact probabilities, but it's something that could very much probabilistically, oh, Jesus Christ, probabilistically, there you go. I can say words. Happen is the federal case gets entirely dismissed. It gets entirely thrown out. There's multiple reasons. The reason cited, one of the main reasons, which I have said from the beginning on this, which is Disney does not truly have standing. They do not meet the elements for standing. Standing means the ability to bring a claim to court. This is exactly the reason that the citizens who actually sued the state of Florida for these legislative changes way back earlier this year, they were thrown out for standing. Disney can be thrown out for much similar grounds. So they're very likely to be tossed out, if not entirely, almost on all counts. So perhaps 4 of the 5 counts might get tossed. You might have one remaining count there in federal court. Yeah, and we saw how that one, they capitulated to everything. All in all, it looks very much, and there's legal mindset, Andrew Esquire, looks very much like his predictions are coming to pass, and that what they're using to try and dismiss this doesn't actually address the actual claim that Gina is bringing forth. Therefore, it will probably go through and the dismissal will be denied. But let me know what you think of this. Make sure to like, share, and sub. If you've done that, thank you. If you're going to do that, thank you. And
well, bye.